Okay, my name is Lita Rosario, and I am an attorney who I consider myself an artist rights attorney and an artist advocate. And I have filed a number of lawsuits. I represented a number of artists and songwriters in claims against record companies and sometimes other artists to recover monies that they were rightfully entitled to that they've never received. And it seems that it's a pervasive problem in the music industry. And to a certain extent, the structure of the industry kind of encourages this to happen as opposed to discouraging it from happening. And so we find ourselves in situations like Liza Rios has with Joe Cartagena, Fat Joe, where you got to file a lawsuit to figure out what actually happened and to find out where is the money. So today, although Fat Joe's lawyers originally filed an answer in the case, they subsequently filed a motion to dismiss, as did Jelly's Jams, not claiming that they don't owe any money, but just making technical legal arguments that basically saying that Liza can't sue them for one reason or another. We feel pretty good about the hearing. There was a hearing that took place today, oral arguments for our side and for Jelly's Jams and Fat Joe to talk about why we believe that they should be kept in this case and why we believe that they basically had fiduciary duties, meaning a higher standard than a breach of contract standard, to pay Liza monies that were due her husband so that her family can benefit. Well, you can never be 100% sure, but there is evidence that there were songs registered in overseas performing rights societies where a larger percentage of the song was claimed by Joe than what the agreement was that he was supposed to receive for that song, for those songs, including How to Be a Player or Still Not a Player, Want to Be a Player, whatever you want to call it. And so there's that, and then there's just this general problem of there's a structure to the way many recording and music publishing agreements are set up that will say, when someone like a Fat Joe, or even let's say if it was a Puffy hypothetically, or a Jermaine Dupri, or anybody signs agreement with an artist, the standard language in the agreement once they sign with a major label or a major publisher is that that major label or major publisher is not actually agreeing to make direct payments to the artist. They're saying that they're just doing it as a favor to the production company. And so one of the issues in this case, which is a far-reaching issue for the music industry and for artists in general, is how to get around those provisions and how do you make the major labels and the major publishing companies accountable for monies that they're earning from the copyrights that are owned by artists and songwriters who don't, for some reason, don't have any money. Somebody's getting the money. And, in the instance of Big Pun, as we all know, when somebody passes away, there's a big spike in their sales. And that spike hasn't been realized. And even if, there are many legal issues that you got to get around to bring these lawsuits, because typically in New York at least there's a 6-year statute of limitation for a general breach of contract claim. And usually by the time artists and songwriters decide to sue, they're far out from when the big money was made from a song, because we all know when they first come out, that's when they make the most money. But other things can happen. They can be used in movies and TV commercials. They get sampled, and those things also provide some very legitimate income that a lot of artists and songwriters should be getting, but for one reason or another, they're not getting it. So we're fighting against kind of this structure in the industry, a standard in the industry where a publisher like Jellybean can say, well, you signed a contract saying that I don't actually have to pay you, even though the contract says that you will pay me. There's other language in the contract that says, but yeah, I really don't have to. And if I don't pay you, there's really nothing you can do about that. And something has to be done about that.
No, there's been the same story that I've been saying since day one. My situation is that, number one, I didn't have the proper representation on my end that could do the job, and secondly, finally, over years, I found the proper representation. And while being with Lita, there's been stuff that came to surface that I have no clue of. So
Yeah, I want to respond to that too because, um, you know, there's you asked if it was a rehashing. Well, in some ways, it's the same issue. The big question is where's the money, right? So, and there's some new information has come to light just of late that is setting some light on what happened to the money. And so that's really why this lawsuit is being filed now. Over time, you're supposed to get royalties twice a year or whatever, and most of the time the accounts are saying they're unrecouped. So when an artist is getting statements that say they're unrecouped, there's really no reason for them to think that there should be money there. In this particular case, we found the reason to believe that there really should be some more money there. And that is that we found out that in foreign territories overseas, that the writer splits are not properly reflected for the songs the way they should have been. And that's indicating that there was some money that was collected there that shouldn't have been collected. So that's what we're after. We're trying to pursue that. Actually, the important thing is that now artists are also getting paid for that money. ASCAP and BMI, the traditional, societies that collect money for songwriters, have been able to collect money for those streaming services and other, new technology types of services. The important thing is that now, at least on the digital side, that artists can also collect that money. And as you may know, or your viewers or your subscribers may know, there's legislation that keeps coming up to have radio stations pay artists performance rights royalties the same way that songwriters are paid. So all that is a big issue. What will become an issue in this case at some point in time is the same thing that happened in the Eminem case with regard to internet downloads, iTunes downloads or Amazon downloads, how an artist is supposed to be paid for that. And as you may know, Eminem's production company and Eminem sued Universal, claiming that they were supposed to be getting 50% of the iTunes money. So on a 99-cent download from iTunes, for instance, iTunes keeps 35 or 34 cents and the other 64 cents gets paid to the label. So the question is, a standard artist royalty is like between 12 and 14%. After they pay off the mechanicals, which is another 9 cents, so that's about 10 cents. So there's about 54 cents left there, and the question is, how does that money get accounted? Does the artist only get 12% of that money, or do they get 50%? And the Supreme Court held in the Eminem case that they're supposed to get 50%. So that's the big issue. And the same question with regard to streaming services, Pandora, Spotify, these other people. And there's legislation, the Copyright Act is up for a huge overhaul right now. And it's really important that artists get in there and let Congress know that they want to get paid more money, because Pandora is screaming and yelling that they're paying too much. Right? And because they're paying the lion's share of those monies. But if broadcasters also had to pay, there'd be a huge spike in that money, and there'd be a lot more money for artists to get paid.